Good afternoon and welcome to our online June Food for Thought. Today's topic is going to be legacy planning, what you need to know in order to prepare. Good afternoon, my name is Anna Apodaca and I'm one of the wealth planners here at Lake Point Advisory Group.
And I'm Kody Followwill. I'm also one of the financial planners here at Lake Point Advisory Group. Here at Lake Point Advisory Group, we're a retirement planning and wealth management financial services firm, but we host monthly events just like this on a variety of topics that we find beneficial for our clients.
We do have a very large audience with us today, and I want to thank everybody for joining. We do have everybody's camera and microphone turned off at the moment, but it's very important for us to hear what's on your minds and some of the questions that you may have as we get through some of the topics. We will have there is a Q&A icon on the bottom of your screen. If you have a question throughout this presentation, please feel free to type in your question and we will address it during the question and answer.
Today we have joining us Margaret Svoboda. She serves as Vice President and Trust Officer of American National Bank of Texas. She's got 26 years in experience in banking and financial planning, but she focuses mostly on administrating personal trusts, estates, and retirement planning.
Excellent. Well, Margaret, I am super excited that you're here with us today. I know this has been a topic that we bring up with a lot of our clients in our planning sessions. So I'm going to go ahead and jump right into some of the most common questions that we hear from our clients. What exactly is an estate plan and who needs one?
Well, thank you for having me. I'm excited to talk about estate planning with you guys. So what is an estate plan and why do I need one? Well, that's a very good question. Everybody needs an estate plan. Maybe you don't need an elaborate will, but you need a sound estate plan that can prevent headaches along the way. So some estate planning tools would be a will, a living trust, a power of attorney, both for medical and financial. Those are all great estate planning tools. So, if you don't plan, someone else is going to have to try to sort out who gets what, where does it go, and how do they get it. Powers of attorneys for financial and medical decisions are extremely important because they can authorize someone to make decisions on your behalf when you are not able to do so. So if you don't have any of these plans in place, how is anyone going to know what to do with you if you aren't able to make decisions? Disabilities are very common, and healthcare providers, financial institutions, and a host of others need your consent to administer financial accounts, transfer property, pay your bills, and render medical assistance to you. So it's very important that you have these tools in place before one of these instances occur, either death or a disability.
One of the most common questions that I get from our clients is, what happens if you die without a will? Can you kind of go into what the process would be?
Sure. So if you die without a will, your assets are transferred under the rules of descent and distribution. So what happens there is an administration has to be opened, which is more costly than the probate process. And everything that is done requires court oversight. So someone has to be appointed to this administration because you didn't plan ahead of time. And everything you do, so let's say you have a house to sell, everything you do requires court approval. So to sell your house, it requires court approval. To pay your bills requires court approval. Everything you do requires court approval if you die without a will. And the rules of descent and distribution, so if you die without a will, then you haven't told anyone how you want your assets distributed. So one example would be an unmarried person with no children. And if an unmarried person dies and they have one parent surviving and let's say a sibling or even siblings. So if you die without a will, then half is going to go to your sibling or siblings and half is going to go to your surviving parent, whether you wanted it to or not. That's how it's going to go. So again, that's why it's important to have an estate plan in place.
Very important.
Yeah. We get a lot of questions when we're in planning sessions about having a valid will. We've heard holographic will. Can you tell us what a valid will is and when it becomes legally binding?
Yes. So a will, a will is a written document that's basically instructions for the distribution of your assets. It becomes legally binding when you execute it. And you mentioned holographic will. A holographic will is a handwritten will. And I have seen those in my experience, not very many, but I have seen a holographic will in my lifetime now. So.
Just a quick follow-up question on that. What would you say the pros and cons are? There's different types of wills. Just what are some of the pros and cons on having one over having another?
Well, because I'm in the business that I'm in, I would always recommend using an attorney to draft your will, even the simplest will. We find ourselves in a world where we can go online and create just about anything we want. And, there are a lot of entities out there, and I won't name any specifically, but there's a lot of entities out there that can create wills for you. So let me give you a scenario of a family that we encountered that the husband had created a will using one of those online entities that you can use to do that. So he created a will, created a living trust. Wife probably knew about it, but she didn't know anything about it. In other words, she didn't know what he was paying for it. She didn't know what he was putting in it, didn't have any passwords, didn't have any access to any of it. He was taking care of it, and that's what she knew about it. So he passes, and she's trying to get access to this document that her husband has created. Well, the entity she doesn't have a password, so the entity won't allow her access to this document because she doesn't have a password to get into the document. So this husband has been paying for this, which, by the way, they're drafting his bank account to pay for this document. And the woman can't even get to this document because she doesn't know any passwords, doesn't know any access. So that's just one horror story that I can provide you, if you do go that route. And again, a simple estate plan, that would be good for maybe a single individual or someone who, doesn't have many assets, but I wouldn't recommend it for anyone who has a higher net worth.
Yeah, thank you.
Got a question on what exactly is probate? I know we hear it all the time, and do you want to avoid probate? Can you kind of go into what probate actually means?
Sure. So probate is just simply the legal process wherein the estate of a decedent is administered. That includes the process of proving the validity of a will and executing its provisions under court guidance. I do want to point out that the probate process in Texas is a easier, more affordable process than it is in some other states. And I don't claim to know other states' laws, but I hear other horror stories, again, about the probate process in other states. But in Texas, it is a fairly easy process, and it's a fairly affordable process. So to avoid probate, you would have to do something like a living trust, which I know are going to talk about a little later in this segment. So.
Excellent. So we talked a lot about, wills and having the right will and doing it the right way. It sounds like you get what you pay for, right?
Right.
And going to the right people. Does it avoid that probate process? Can you kind of walk us through what that would look like?
So a will does not avoid probate. You have to go through the probate process, which is what I just mentioned. You have to go into court and prove the validity of a will and execute it under the court's guidance. And that's, again, easier in Texas, but you can't avoid it with a will. There could be some other avenues that you can explore depending on what type of assets you have. Since I'm not an attorney, it's not advice I would want to give, but again, there are other avenues, but they would still require some type of court guidance for that process.
Okay.
I've got a question coming in from Armando. He kind of wanted us to elaborate a little bit more on that password protected. Can you go a little bit deeper into that story? Like what happened with that wife that couldn't get to the will?
Well, they contacted our bank for assistance. So our bank serves so we have trust powers, and most banks that have trust powers can serve as a corporate executor and corporate trustee. So they contacted our bank to see if we could assist in helping this woman get access to this will, which we could not. And she, at that point in time, she didn't want to spend money to seek the guidance of an attorney. We don't actually draw up in our department. We don't, draw legal documents. We don't give legal advice. We don't do any of that type of work. And so we had to step away from the situation because, again, we couldn't help her with the legal process.
Ouch.
Yeah.
Well, thank you for that, Armando, for pulling that up. But getting back to estates or wills, I've got a common question. Who should you consider, or who should I consider being my executor when it comes to setting up these trusts?
Okay. So, sometimes people think they're doing a person a favor by naming them as their executor, which really you're not necessarily. A lot of people choose a family member. A lot of people choose a friend their own age. And what typically happens there is if I'm 85 and I choose a friend my own age and, we die at the same time, then obviously I haven't chosen very well if I've done that. So a lot of times when they choose a friend their own age, that friend is not able to, carry out their wishes because they're simply not up to the task, or they have health reasons, or they've even predeceased them. When you are choosing an executor, you need to consider what the impact is going to be on that person, because unless you are experienced, people are not experienced in gathering assets and don't realize what the task may be. So that's, as I mentioned before, that's why, our bank can serve as a corporate executor. We also take that emotional tie out of it, since we're not a family member and we're not a friend, especially in instances where there might be blended families or, complex estate administration. Choosing a corporate executor might be the right fit, for someone. So I would always recommend that. A lot of times when we are meeting with clients, we might recommend that you, if we're talking with a husband and wife could name one another, but we suggest naming an alternate executor, such as a corporate executor. So in the event that one spouse passes, another could be named. And I would say that to anyone, not just a husband and wife. If you Kody wanted to name a friend as your executor and name an alternate, say a corporate executor, then I would suggest something like that. That way, if the friend doesn't want to serve, then they can step down and allow a corporate executor to, to move into that position.
We got a great question coming in, Tanette. With a will, what does the executor do?
That's a very good question. So with a will, the executor gathers your assets. If you own a home or they pay bills, they plan for an estate sale, they carry out the wishes that are actually laid out in your will. Sometimes people don't want an estate sale. Sometimes people want everything given to charities. There's lots of different scenarios. So the executor is responsible for gathering those assets, paying the bills, selling your home, selling your cars, transferring your assets to the beneficiaries. Well, whatever your will states, however your assets are laid out, the executor is responsible for preparing what's called an inventory, and they have to prepare that inventory to show the court that they have gathered everything that you own, and they're going to administer it according to the terms of your will.
We've got another great question coming in from the chat from Michael Peters. He wants to know, what percentage does a corporate executive usually get if they're to be named the executor in a will?
So I can only speak for my bank. So on the first $5 million, we charge 2% of the market value of the estate to administer the estate. And it's a graduated scale when it's more than that. We have a $10,000 minimum fee for our estate services, and there can be some other fees involved, such as if we don't use a real estate agent, let's say, to sell your home, then we may charge a percentage to sell your home or sell any other real estate you might own.
Excellent. Well, moving away from the topic of wills, I hear a lot of clients, they come in with questions around trust and what trust is right for them, whether it's a living trust and an irrevocable trust. Can you tell us in a nutshell what a trust is and who benefits the most from opening or establishing a trust?
Sure. So a trust is an entity that holds assets for the benefit of certain other persons or entities. So there's many types of trust. There's a living trust, which we're going to talk more about. There's testamentary trust, which is actually created through someone's will. There's charitable trust. There's special needs trust. There's many types of trust out there, but the one we probably want to talk about the most here is a living trust. And that's something, it's revocable, and it's something that's created during your lifetime.
Excellent.
One of the questions, when would you might consider establishing a trust?
Well, that depends. Wills and trusts are both excellent planning tools. And so it depends on how you're seeking to manage your assets. How do you want to control your assets? Many types of trusts exist, each designed for specific purpose. I do want to point out that establishing a living trust does require the services of an experienced attorney. I would never suggest trying to create your own handwritten living trust. I would always recommend the services of an experienced attorney to do that.
And another great question from Anonymous. What is the difference between a revocable trust and an irrevocable trust?
So a revocable trust or a living trust is can be created now. You can create a living trust to handle your assets right now. An irrevocable trust is, I mentioned a testamentary trust, which is something that you would create through your will. So a lot of times husbands and wives, well, and it's not just husbands and wives, they'll create trusts in their wills for one another, or husband and wife will create trusts for their families in their will. Those are irrevocable trusts, and they don't actually take place until after you die, or they're not actually created. So you can establish all of the guidelines in your will, and when you pass, then those guidelines are fulfilled through this testamentary trust. That's a very good question.
Mhm. Yeah. We talked a little bit about the advantages and disadvantages of a will. What would you say the disadvantages and advantages are, whether you should go the trust route or the will, or a combination of the two? What would be your guidance on that?
So, there are advantages of both, and there's disadvantages of both. So the advantages of establishing a trust over a will is, many people want to avoid probate. And as I mentioned, probate's an easy process in Texas, but it is not as easy in, someone told me the other day that the probate process in Oklahoma is very difficult and very expensive. And I don't mean to pick on Oklahoma, so please don't think I am. I'm simply quoting what I was told. But so in Oklahoma, a lot of people create living trusts rather than wills because the probate process is so difficult. So the biggest advantage is creating a living trust is it avoids probate. Property that passes by a living trust is not subject to probate, where property that passes by your will, of course, is subject to probate. Also, establishing a living trust, you can change that at any time. You can change the beneficiaries, you can change the trustee, you can change the terms. So if you get mad at your kids, you can take them all out or put them all back in. There is a cost to that. Every time you modify it or update it, there is a cost for it, but you can change the terms as long as you're alive. You can continue, to change the terms until you die. The other thing it does is a living trust can protect you against incapacity. So if you can't handle your affairs at any time due to illness, injury, then the successor trustee can step right in and start handling your affairs. And that, that's a great planning tool. And we talked about powers of attorneys for, financial and for medical, earlier in this segment. So, in the absence of a living trust, then you would need a power of attorney for medical or financial in place. Otherwise, your family may have to take out a guardianship on you to manage your property. And that's actually a whole nother topic that we don't have time to discuss today, but just know that the importance of the planning of having a power of attorney for medical or for, finances in place is important if you don't have a living trust, in place to take care of that. A living trust can also continue after your death. You can direct the trustee to hold your trust property for a beneficiary until they reach a certain age, until they get married, or for their lifetime. The same can go for a testamentary trust that we talked about that's created in your will. You can set up those same type of guidelines, but living trust can continue even after you die. And so there are, several advantages to doing that if that's the planning tool that you want to use. You asked for disadvantages. Property in a living trust is generally not protected from creditors. So let's talk about what that means. If if you create a testamentary trust through your will, that trust is irrevocable when it's created. When you pass and the trust is funded, that trust is irrevocable, and it's creditor protected. So if I'm driving down the road and I hit someone and they sue me, they cannot touch any of the assets in my irrevocable testamentary trust. They can take my house, they can take any assets I have outside of that. They can probably take the assets I may hold in a living trust, but they cannot take the assets that are in an irrevocable trust. So that's one huge disadvantage to creating a living trust, if that's what you're trying to do, is protect, your assets from creditors. Another issue is, for the trust to be of any benefit, you have to transfer property into it. It's called funding the trust. And that a good attorney is going to guide you through that process of deeding your property into trust, titling your assets in the name of the trust, deeding, I said deeding your property, I'm sorry, opening trust checking accounts. You are going to want to have these items in place. Also, you want to make sure you change beneficiary designations. And again, a good attorney is going to guide you to do all of these things if you are creating a living trust. Otherwise, you have created this living trust and spent this money for nothing if you don't follow these guidelines when you're setting it up.
Good question on that topic. How often or how frequently would you recommend updating or renewing these documents?
So we suggest reviewing your trust or will every 5 years, or if you have a life-changing experience, the death of a spouse, the birth of a child, a marriage, a divorce, we suggest changing those documents at that time, or at least, looking at your documents every 5 years and making sure that everything is still in order.
Another good question came in on how do you fund a living trust? What's the process on that?
So funding a living trust is deeding the assets to the living trust. So like we said, changing your, deeding your property, meaning your house. So your assets are going, the house, instead of being titled in your name, it's not going to be in the name of Margaret Svoboda anymore. It's going to be in the name of the Margaret Svoboda Revocable Trust. And that's how the deed is going to look. So an attorney is going to have to prepare deeds to your house in order to get those, in order to fund the trust. Good question.
Great question.
Yeah, we've got a lot of questions that are coming in from the Q&A, and if you're okay, if we have a little bit of time, I'd like to go ahead and get some of these out there.
Sure.
So I've got a question from Jim. Jim wants to know, what does a durable power of attorney cover?
A durable power of attorney can cover what you want it to cover. That's another thing that I would recommend seeking an attorney to have that drawn up, and not go out to the internet to do that. A durable power of attorney can give the agent powers to sell property. Some can take that away. If you don't want anybody to be able to sell your property due to your incapacity, then you don't have to have that in there, but it can cover a wide range of everything. I mean, it can even go as far as if you were using gifting methods. Let's say you were gifting to your family members, you can even instruct your power of attorney to continue your gifting process if you are incapacitated. I do want to point out, though, that if you have a durable power of attorney and you die, that durable power of attorney is voided. That You don't have it, the power of attorney does not have access. Once you die, it's no longer valid.
Awesome. I was going to ask a question for Tanette that came in. She asked, so executors have access to your assets, or are they legally authorized to sell your home?
So the executor, once they go through the probate process, you are going to be given, through the probate process, you're going to be issued letters testamentary. And that letters testamentary spells out who is authorized, meaning the executor. So who is authorized to sell your property. So in order to sell your house, they're going to need that and a copy of your death certificate to do that.
That's for like brokerage accounts. That's for just about everything.
Yes. Yes.
Great question.
All right, we'll take a couple more. I've got a question from Anonymous here. We've got, do the beneficiaries designated in a brokerage account override the beneficiaries designated in your will?
Do you guys want me to answer that?
Go for it.
So if you have a designated beneficiary on your brokerage account, then that passes outside of your estate and doesn't matter what your will says. In fact, if you have designated beneficiaries on all of your accounts, and here's a good example. If you have designated beneficiaries on all of your accounts and you're trying to set up a testamentary trust in your will, and you want to fund the trust with $1 million, but you have beneficiaries on all of your accounts that are going to fund this trust, well, all of that money is going to pass outside of your estate, and there is not going to be any money to fund that trust in your will.
So you have to make sure that the trust is the beneficiary.
Either the trust is the beneficiary or there is no beneficiary. And then usually that will pass to your estate if I'm correct on that and on the financial side.
Let's see. Good question, Anonymous. Way to go. Let's see. We've got one from Dave. Let's see. So with so many blended marriages, could you tell us a common risk that arises when there are no documents in place?
Yes, I can. And there
That's
are
common. It's very common.
It's, oh my goodness, it is very common. So there are lots of, there's, Texas is a community property state. So there's lots of different scenarios. And I would suggest that if you have nothing to do one day, you look up the rules of descent and distribution in Texas or in the state that you live in. So if you are a married person and you have a blended family, I happen to have a chart in front of me, so that's why I'm got some paper here. Because again, like I say, there are so many different scenarios. If a decedent has separate property, here's an example. If a decedent has separate property and has a surviving spouse and children, then 1/3 can go to the surviving spouse. This is with no will. 1/3 goes to the surviving spouse. 2/3 can go to the children. The surviving spouse can have a life estate in the house that you own together, but the children can take all equally, subject to the surviving spouse's 1/3 life estate. So, there's a lot of different scenarios. Community property, the children, blended family children could take all of it except for your 50%. So they will get your husband's 50% and you get to keep your 50%, but that's, that's it. But the children could take all and the surviving spouse could get nothing in a blended family situation. So here again, another reason to have some kind of planning tool in place.
And it looks like the good question from the Bakers came in. Do you want to do that one?
Yep, absolutely. So we've got a question for Mr. and Mrs. Baker. Do other titles, boats, cars, etc., can they be titled in the trust as well? And do you provide the terminology needed to revise all of the brokerage accounts to trust the fund?
So a good attorney, and you want one experienced in estate planning. I would never suggest that you go to a family attorney to prepare your estate plan. And the reason, just because they're an attorney doesn't mean that they're experienced in it. So I would always suggest first off that you go to a good estate planning attorney. And that good estate planning attorney is going to walk you through how to retitle your assets in the living trust. Typically, you're not putting cars into living trust, and those transfer by affidavit of heirship. And part of that, one of the reasons we talk about that is because when I talked about the creditor protection language, you wouldn't want a car in a trust that, you know, someone that you were driving down the road in and hit someone and they're suing you and you're trying to protect your assets. So typically, you know, cars are not put into living trusts. Boats, what kind of boat? Are we talking about just a little John boat on the water? Are we talking about a boat with living quarters? You know, that might be a different scenario, and I would confer with my attorney on that answer in that case. So.
Good question.
Great question coming in. Do IRAs and annuities need to be funded by the trusts?
That is a good question. And something that we are starting to see, or I guess we're seeing, a lot of attorneys are putting, what I'm seeing now is a lot of attorneys are putting retirement language into IRAs and setting up retirement trusts in the event of someone's death. And as you guys know, the laws for IRAs changed just a little bit in, I guess, 2020, such as stretch IRAs or beneficiary IRAs no longer get that lifetime payout as they were back in, I believe it was 2018. I believe that changed in 2019. Is that right?
That is right.
And so, you know, I handle right now a couple of retirement trusts. I think they seem to be good vehicles. Some people may say they aren't, but if you're trying to protect someone or trying to protect those assets from being, you know, all spent, then I would suggest doing that. And you would name the trust as the beneficiary so that it would, you know, go into your trust. Now, you know, if you're going to have to deplete it in 10 years, well, I would rather see that monies go into a trust than see it, you know, be frivolously spent by someone that you didn't want to do that. So, you know, I'm seeing it more and more, and I still think it's a good vehicle. You know, there are attorneys who may disagree with me, but what I'm seeing or the ones that I am seeing, I think it's a good way to protect it and, you know, keep that money intact. And there's different ways you can do it. I have a retirement trust right now that pays out the RM, and it was funded prior to the rule change, but so it gets the lifetime stretch, but it has to pay out all of the RMD to the beneficiary annually. Well, I personally would rather it accumulate, and that way that money stays in trust and it stays protected, because that is an irrevocable trust. You know, it depends on how it's drawn up, and so I still think it's a good avenue to go.
Absolutely. Thank you. That was a great question.
Yeah.
We've got just a few more questions. This is from an anonymous person as well. It's a question around blended families. I am married, but my husband is not part of my estate. I had the house and retirement before we married. How do you think this should be handled?
So it sounds like that you have separate property, and hopefully when that time comes, you can prove that separate property. And a good estate planning attorney will go through that process and walk you through that process when you are, having your will prepared. So, and as long as those assets can be identified as separate property, then they should be able to be distributed, any way you want them to go. But once they've been commingled, or anytime it can be proven that it's commingled, then, there could be an issue there.
Awesome.
Going back to living trust, we got a question from Jim. Does a living trust require probate?
No, a living trust avoids probate unless you don't title all of your assets in the living trust. So, as we get older, we forget to do things. And so when we create these living trusts, we've got to remember, or our attorney has got to guide us to make sure that we put all that property in that living trust. And so what I typically see happening in my 14 years in the trust department, I have seen a living trust work maybe twice the way it's supposed to work, meaning it was funded correctly, everything was transferred correctly, and no one forgot to retitle any assets. The rest of those forgot to, so let's say you did this living trust and you bought a house 2 years ago, but you didn't put that into the living trust. So if you were trying to avoid probate, then the very reason you were trying to avoid probate, you just now put yourself into probate because you didn't put that new house you bought into this living trust. So
You gotta cross your T's and dot your I's.
that is correct.
Yeah. I guess, along the same lines, we actually have a question that's somewhat related to this. Is there a need to set up a living trust if single and all assets will be willed to my kids?
If you were, no, not necessarily. I mean, again, the probate process in Texas is easy. And if you're in Texas, then if you set up a will, then there shouldn't be any problem as to, having those assets transferred. I will say this: if your children are minors and you don't set up, if you don't establish, let's say, a trust for them, or let me give you a scenario. I currently have a trust, a 1301 trust, which is a court-created trust, where a grandfather left his minor granddaughter as the beneficiary on his brokerage accounts, and he ultimately passed away. And so now the court would not allow the mother and father to come in and be appointed as the guardian of this child's estate. So they made the parents create a 1301 management trust, which is court created, requires an annual accounting by the court because the court wants to see how you're spending that money. And this will be in place. This little girl is 7, so it will be in place until this little girl turns 25. But those are some of the processes that can happen when you don't name a beneficiary properly, or when you don't make arrangements properly. Things you were trying to avoid, and especially for minor children. And I don't know in your brokerage firm, but in this brokerage firm, apparently they didn't ask how old the beneficiary was, or didn't get any information, or maybe they just didn't care. Maybe they just wanted to, I don't know what the rules are, on that, but, they didn't, I gathered from my conversations with the financial advisor that he didn't know how old this child was, or didn't know that she was a minor when, his client named her as a beneficiary. But this is a scenario that can happen if you are naming minor beneficiaries to, as your beneficiary. So, and that's probably a topic we could touch on as a whole segment.
Yeah.
Very comprehensive.
Yeah. Do you see, so another question we got from Daryl, can an LLC be used instead of a living trust?
That is a good question. And there are LLCs that are used, not necessarily in place of the living trust, I don't think, but I think I would want to refer you to your attorney to answer that question. If you're asking me, can I use an LLC rather than creating a living trust or a will? I would say no, but that would be a question I would refer you to your attorney to answer.
And those who are watching, we got a little bit more time for some more Q&As. The Q&A box is down there at the bottom of the screen. If you want me to ask those, be sure to get them in as soon as you can. If we can't get to them, we can always circle back.
All right.
Anna, you want to go ahead and take another one?
Yeah, I'll go ahead and take another one. So this question comes in from anonymous, and it says, I have a timeshare and I supposedly left it out of my revocable trust because none of my kids wanted it. Will this end up in probate?
That's a good question. And I might want you to refer that question to your attorney. I would say yes, it would end up in probate. I have only dealt with two timeshares over the last 14 years, neither one in a living trust, but both as part of an estate. And in one scenario, the kids wanted it, and in the other scenario, the kids didn't want it. So I would definitely refer that question to your attorney and see how he guides you on that.
Great. All right, got one good question here. And this is really just after somebody passes, what happens to all of the debts? Do they have to be paid off, or is the family on the hook for it?
That's a good question. So depends on what kinds of debts they are. Secured, unsecured. Unsecured would be like, credit cards or things like that. Secured would be like your house. So, as we go through the probate process, we file an inventory. We have to file notice to these secured creditors and different entities. That's what our attorney, that's why an attorney is involved, and that's our attorney has to draft all of those letters and notices that go to those to those entities. Are you responsible? Well, if there's no money in the estate, then there's no money to pay. There's no money to pay for those debts. So I don't think that you are responsible as let's say you're a beneficiary. I don't think you can be held responsible. Again, that might be a question you refer to your attorney, but I don't think you can be held responsible for that.
Awesome. Well, a hot topic that's on is those blended families again. So a question from Anonymous, who's asking great questions. My son has separate investments from his live-in girlfriend of 5 years and prefers to keep the assets in his family. They have no kids. Would a trust or a will be better for him?
Well, both are great planning tools. If he does a living trust right now, and I think that would, that could be a good way for him to, keep those assets. But I think he could do the same thing in a will. He's not married to this girl, and unless she could prove some sort of, I don't know if you said they live together, but unless you could prove some sort of common law marriage, I don't
Right.
see how she could take advantage of those assets. So I think either one would be a good planning tool, to use.
That kind
If he, go ahead.
of, no, go ahead. No, go ahead.
I was going to say, if he thought he was going to marry her, and he was, these were assets that were family assets that he wanted to keep as family assets, then I would suggest a prenup prior to that marriage.
And I guess that kind of leads me back into earlier topic when you're saying that there are costs associated in making those changes in the trust. Is that expensive? Are they minor charges?
So, creating a living trust does require, the expertise of an attorney. There is more cost on the front end of creating a living trust. There's less cost in creating a will. But every time you amend it, every time you make changes to it, or every time you buy or sell a piece of property that has to be deeded in or out, then an attorney has to do that, and there's cost associated with that. And if you spend all this money to do this, and then you buy a piece of property and have to go through the probate process anyway, then you've spent all this money for nothing, is the way I kind of look at it. So yes, it can be an expensive process up front, but if it's done correctly, then the costs at the end of it can be minimal.
Excellent. All right. Well, I think we're running up on the hour. We have one more question, and I apologize if we didn't get to everybody's in the chat, but one more question to kind of top us all off here. We've got a question. Is there a professional organization or something similar so that we can ensure that the attorney that we're leveraging is specialized in family planning, or or current plan does not include a trust because our attorney did not know about the professional organizations who can manage trusts?
Wow, that's a good question.
Mouthful.
That's a really good question. So, the Texas Bar has a website, and you can go on that website and find attorneys who specialize. I would do my research. There's lots of information out there on the internet, as we all know, and I would do my research. I mean, a lot of times you will find information about attorneys out on the internet, and whether or not they are good attorneys. Word of mouth is always a good way to find attorneys. But I do want to say, you want to make sure that they do specialize in estate planning and probate, because that's going to be the key. I mean, if they're a divorce attorney, then they're not up on the laws that go with estate planning, and vice versa. An estate planning attorney doesn't do divorces because he or she may not be up on those laws. So, I would make sure that they are specializing in it. Again, word of mouth. Call your financial institution. We sometimes, if people call us all the time for us to recommend an attorney, and while I don't recommend, I give suggestions, and I usually try to give 2 or 3, of attorneys, possibly ones I've worked with in the past, and or ones that I am associated with. So that's how I would go about it. You could even go to your banker at your bank and request that information. They may be able to give that information to you as well. or your financial advisor. So those are all avenues I would explore.
No, that was a good place to end on, Margaret. I really appreciate it. I want to thank you, Margaret. I think you did a fantastic job answering a lot of the questions that we had and our clients had, and really helped clarify some things. I want to apologize if we didn't get to your question. I do apologize, but it is very important that, you know, we do answer and address any questions that you have. So if you have a question that didn't get answered, or there was something that you didn't want to ask, I ask that you please reach out to your financial advisor to schedule some time and hopefully address some of these things that Margaret was so gracious to bring to our attention today.
If you'd like some more information from Margaret, you can visit her website, the American National Bank. So it's www.anbtx.com. Her email is her name. It's Margaret Svoboda, and I'm going to spell that for you. It's SVOBODA at anbtx.com. Margaret's phone number is 214-863-6801.
Awesome, Kody. Well, I want to thank everybody for being a part of our discussion today, and especially you, Margaret. Thank you for all your expertise. As always, we enjoy talking with you all, and please call us if there's anything that we can do to help you all to plan for the future.
If you want more information on us, you can visit us at Lake Point Advisory Group. It's a long one.com. Or you can give us a call, 214-771-3363. Thanks again for joining us, and hope to see you guys on next month's Food for Thought. Thank you, Margaret.
Thank you, Margaret.
Bye.
Bye-bye.